I want to say something about the concept of danger for the purposes of these provisions, that's Section 100 and Section 44 of the Employment Rights Act. Danger has been interpreted broadly in the case law, and in the case of Harvest Press Limited and McCafferty, the Employment Appeal Tribunal looked at the concept of danger and in particular said this as to the submission that the circumstances of danger referred to in Section 100, subsection 1D, means the circumstances of danger generated by the workplace itself. It seems to us that this is too narrow a view of words which are quite general. It seems to us that the premises or the place of work may become dangerous as a result of the presence or absence of an employee. For example, premises might become unsafe as a result of the presence of an unskilled and untrained employee working on dangerous processes in the workplace, where the danger of a mistake is not just to that employee, but to the colleagues who are working with him. It seems to us that the circumstances of danger contemplated by Section 100, subsection 1D would be apt to cover such a situation, and it seems to us that had a fellow employee walked out because of the presence of an unskilled and untrained operative in those circumstances, he'd be entitled to the protection of the legislation. So the legislation is apt to include the situation where you're at risk of contracting COVID-19. It's important to remember, however, that you need to have a reasonable belief that the danger is serious and imminent. Now, although there's a reference to the circumstances of danger in the statute, you don't actually need to show that the danger existed. The question for the tribunal is going to be whether you reasonably believe that attending the workplace would put you in danger. So this raises the importance of what goes towards your reasonable belief. And one of the important things is the effectiveness or otherwise of your employer's communication on the measures they've taken to minimize the risk. Now, there's a case on this that you can have a look at called Edwards and the Secretary of State for Justice, which goes into a bit more detail on this. One of the questions that is being raised at the moment is whether the serious and imminent danger test is going to be less likely to be satisfied where the level of cases of COVID has dropped significantly. My view is probably not. What matters is that the situation in the particular workplace has been analysed. And so in considering whether you've got a reasonable belief that the danger is serious and imminent, you need to have a look at the steps that your employer's taken to reduce the risk and how visible and well communicated those strategies are. So it's important to remember that the employer is not required to eliminate the risk. The question is whether they've taken adequate measures and whether you've got a reasonable belief in a serious and imminent danger in those circumstances. It's important also to say that your own health may be relevant in this context. So that if you're somebody, say, who might be categorized as vulnerable, or if you've got, say, a suppressed immune system, you might be put in serious and imminent danger in circumstances where an employee without that health condition wouldn't be. And similarly, your belief that you've been put in a serious and imminent danger might be reasonable. In this part of the talk, I'd like to deal with Section 44 of the Employment Rights Act. Now, this is available to you if your employer does something which isn't dismissal, but maybe some form of punishment. In those circumstances, you may have grounds to bring a claim under Section 44 of the Employment Rights Act. This provides that you have the right not to be subjected to any detriment, whether by action or failure to act, by your employer, which is done on the ground that you did any of the things that I talked about in part 1. It applies from day 1 of the contract, and it applies to workers as well as employees for the same reasons as I gave in part 1 of the talk. A worker who succeeds in establishing this claim will be entitled to compensation, including compensation for injury to feelings. It may often be sensible, if you have to bring one of these claims, to include a claim for whistleblowing alongside it if you brought to the attention of the employer the fact that health and safety may have been endangered for anyone. But there's an important distinction between the two different types of claim. One is a claim that you have been subjected to a detriment because you did an action, that you removed yourself, for example, from a serious and imminent danger. But the whistleblowing protects you from being punished for having made a disclosure. So sometimes tribunals will draw a distinction between a punishment which was given, for example, because you walk off a job, and are not prepared to treat that as punishment for having made a protected disclosure. Turning then to the whistleblowing provisions, which are complicated, but in broad outline, if you're an employee, you can claim that you've been unfairly dismissed if the reason or principal reason for the dismissal is that you've made a protected disclosure. And you can find that in the Employment Rights Act at section 103 capital A. Workers who are not employees can claim in respect of detriments. Now, this includes the detriment of having your contract terminated, if that detriment was given to you on the ground that you made a protected disclosure. Under the UK legislation, an employee who's dismissed can seek what's called interim relief if they're bringing a whistleblowing claim for unfair dismissal. This is a quick procedure, and you have to get your claim into the tribunal within a very short period of time of having been dismissed. Now, whether a whistleblower will qualify for protection on that basis depends on satisfying a number of different tests which relate to the type of information that was disclosed and to whom it was disclosed. So first of all, is the information a qualifying disclosure? There are a number of requirements that need to be satisfied in this regard, and they can be found in section 43 capital B of the Employment Rights Act 1996. So there must be a disclosure of information as opposed to something which in its context amounts only to a general allegation. Secondly, you have to have a look at the subject matter of the disclosure. The information has to relate to one of 6 types of relevant failures under the Employment Rights Act. Now, the relevant failures, which are likely to come up in the context of health and safety matters, are breach of criminal law, breach of any legal obligation, and this might include health and safety obligations to provide appropriate PPE or provide a safe system of work. They could relate to danger to the health and safety of any individual, and notice that the danger to the health and safety of any individual isn't necessarily an individual who works for the employer. It could be a member of the public, or it could be somebody with whom you live, for example, a vulnerable person who's in your house. Finally, a relevant failure will include deliberate concealment of information which relates to any of the matters I've just been talking about. Next, you need to have a look at whether you've got a reasonable belief that the information that you've disclosed tends to show one of those relevant failures. And next, you need to consider whether you have a reasonable belief that the disclosure is in the public interest. Well, if you get through all of those tests, then the question is going to be asked whether the qualifying disclosure that you've made is a protected disclosure. The details of the tests involved here are in sections 43 capital C through to capital H. Now, this broadly depends on the identity of the person to whom the disclosure is made, and the principal way that the legislation encourages you to make disclosures is to your employer. So that's the primary method of whistleblowing. However, you can make disclosure to third parties. These can be made if slightly more stringent requirements are met. You can make disclosures to a responsible third party, so that's somebody who's got a particular interest in the wrongdoing, for example, or a prescribed person, so that might be a regulator, and there's a list of those which you can find. Those are third parties to whom it's relatively easy to get protection if you make a disclosure to them. However, if you engage in wider disclosures, such as to the police or to the media, your disclosure will only qualify for protection in very limited cases. And the conditions which you have to satisfy will only be relaxed where the failure is of an exceptionally serious nature. And for that, you should have a look at section 43, capital H of the Employment Rights Act 1996. So suppose you're able to satisfy the tribunal that you've made a qualifying disclosure and that it's protected because you made it to the right person in the right way, then you will need to be able to satisfy the tribunal that you've been subjected to a detriment. Now, you've got the right not to be subjected to a detriment on the ground that you've made a protected disclosure. You can find this in section 47, capital B1 of the Employment Rights Act 1996. In this context, worker gets an extended definition. It will include self-employed doctors, dentists, ophthalmologists, and pharmacists in the NHS. It's going to include agency workers, police officers, student nurses, and midwives. Junior doctors are included both in respect of the trust that employs them and also in respect of Health Education England, which is responsible for education, training and workforce planning for all NHS staff in England. Now, you can find that extended definition in section 43K of the Employment Rights Act